New additions to an old law are designed to make it easier for state judges to order homeless people with mental illness to receive treatment. Supporters of the amended law, called Assisted Community Treatment, say it will help vulnerable members of our community get the care they need and deserve. But how does the law work? And are civil liberties for those involved protected? Tonight's live broadcast and live stream of Insights on PBS Hawaii start now.
Aloha and welcome to Insights on PBS Hawaii. I'm Laura Yamada. Well, the 2013 Assisted Community Treatment Law, or Act, was intended to help individuals with serious mental illness get medication they need through a mandate from a state judge. Yet the law turned out to be pretty tough to implement, and since then, fewer than 10 court-mandated treatment plans have been issued. The law was amended earlier this year to make it easier for advocate organizations to petition the court to order psychiatric treatment. And while there was strong support for the law, there are concerns that civil liberties are being protected. Our guests tonight include representatives from a homeless advocacy group that is already petitioning the court for mandated treatment and representatives looking to protect the rights of homeless individuals. So we look forward to your participation in tonight's show. You can email, call, or tweet your questions, and you'll find a live stream of this program at pbshawaii.org and the PBS Hawaii Facebook page. All right, now to our guests. Connie Mitchell is the Executive Director of the Institute for Human Services. IHS is a nonprofit that focuses exclusively on ending and preventing homelessness in Hawaii. Chris Thomas is an attorney representing IHS in petitioning the court for assisted community treatment. He is a former prosecuting attorney for the U.S. Air Force and has also worked for the U.S. Attorney's Office in Hawaii. Josh Wish is the Executive Director of the American Civil Liberties Union in Hawaii, which, among other things, fights to protect the constitutional rights of all U.S. citizens. And Phyllis Hironaka has worked for the Hawaii's Public Defender's Office for more than 30 years. She is a graduate of Punahou School, Stanford University, and UCLA Law School. And she is also the president of her father's 442nd Veterans Club chapter. Busy folks that we have here at the table. Thank you so much, all of you, for joining us. This is an important conversation. So let's kind of get right into it. And maybe I'm going to turn to you first, Connie, to just talk about this assisted community treatment law and just explain to people just how does it work?
Well, it's really about identifying people who, because of their mental illness, severe mental illness, really are not able to care for themselves, in a way that really becomes very detrimental to their health. A lot of them experience a lot of wounds. They become victimized. They really don't have the capacity to make the decisions that would really afford them the kind of treatment that is really helpful to them. And so they object and they don't receive the treatment and they continue to deteriorate, and many times they are homeless, as we had mentioned before. So we really want to be able to go to the court to help make that decision, since that person can't make that decision anymore. So I think as a person, as a nurse myself, it just pains me, to see that there are so many people who need treatment that just aren't able to access it.
So what are your perspectives? The law has been morphing and changing over the years, and there's some new things that have happened recently, and so I'm going to let all of you chime in on that. But before we do, let me just get to this question too. Let's talk a little bit about the kinds of mental illness that, well, oftentimes, not always, but oftentimes people who end up homeless or houseless have. What are you seeing? Explain to people a little bit the different types of mental illness that you're seeing that's severe, and it's going to start to fall into this category that we're going to talk about a little more.
Well, I think, most people understand schizophrenia, where you're very disorganized in your thinking. You really can't plan or think clearly enough, to get what you need. So that's one of the things. Bipolar illness, these are serious mental illnesses. They are treatable. And there's also depression, really, really bad depression that really immobilizes people as well. But we also see a lot of traumatic brain injury. that robs people of their ability to make decisions as well, or disinhibits them sufficiently that they can't really make good choices. So they often will end up being arrested for their behavior as well. And if they don't get arrested, they just deteriorate because they can't care for themselves. So they could be just sitting in their own excrement and urine for a long period of time. I had one person that we outreached for months, and then she finally had to go to the hospital because, she kind of fell over one day. She was sitting there forever, and she had a decubitus ulcer that was down to her bone. And, that was something that should not have happened as far as I'm concerned. She was mentally ill.
So, Josh, how often are individuals that are in this type of situation, whether they're homeless, houseless, or not, are you coming across? Are you having to deal with in your area of expertise?
Well, so at the ACLU of Hawaii, we've been trying to do a lot to actually get out into the community and not just be kind of the ivory tower lawyers. So there are a lot of people in our affiliate, including myself, who've gone out into the parks and to the beach parks and to the street and to talk with people who are houseless and to find out what they need from a legal perspective, to see if they know what their rights are, what their civil rights are, both with respect to this and other things the city is doing along the lines of sweeps. And what we've generally seen is they're just, they're people living in a community. And I think that's something it's worth kind of underscoring. These are people living in our community, and I think they're far too often dehumanized. These are friends and neighbors. They have family living in nearby towns. And so when we look at it from that perspective and looking at this law, we've got a few concerns. If I can just take a second and kind of just go kind of quickly through.
Before you do, let's sure. Kind of let's set it up a little bit here first. So I'm sure all of you can talk about this, but let's get people up to speed as to what's been happening. Explain the law a little bit more. What's it about, and what's happened recently that's changed?
I think the concern initially was that the law was being underutilized to such a degree that it wasn't really even worth seeking a petition.
And this is the Assisted Community Treatment Law they're talking about, or called
Correct.
ACT.
It's a chapter 334 of our statute, and it deals with mental health. And as you noted in your introduction, it has been used only a handful of times in the last 5 to 10 years. And based upon that, Connie and her folks have always advocated for incremental changes to the law, and recently, as 2019, kind of an overhaul of the statute to where it's been reduced and streamlined to some degree, so it's easier, in our opinion, to implement.
So at its core, how would you explain what this law does?
It allows the unique opportunity of care providers like Connie Mitchell and IHS to not treat individuals in a hospitalized setting and not treat them in jail or as incarcerated persons, to allow them the freedom to live in their community, but adhere to a course of treatment under the care of a physician. So I appreciate the concerns of the ACLU and anybody who's concerned about the civil rights aspect of these treatment plans. But in our estimation, it affords these folks a greater freedom of being able to live in their own environment, even if it is on the streets, but to be managed properly so that they can not only protect themselves, but we can also protect society. So the ACT law is allowing doctors and care providers like Connie to actually treat individuals in the community, on the streets, in the parks, wherever they're living, wherever they're found.
And you're specifically talking about the up to the amended version that just passed this year. So let me show a few of the graphics that we have here to kind of break it down for people a little bit. Again, we're kind of going back and forth a little bit, that they might see these graphics and might appear a little bit broad, but we'll talk about it a little bit more. So the first one here, we're talking about some of the criteria, again, bullet pointed, so it's much longer than this. Criteria: the person is, 1, mentally ill or suffering from substance abuse, unlikely to live safely without available supervision. And we have a couple more bullet points and some graphics here. The person also has refused needed and appropriate mental health services, has a history of refusal, becomes dangerous to self or others. And I think we have one more graphic that we can show. There's a quote that's a portion of the language in the law. The treatment is considered medically appropriate and is in the person's medical interests. So give us your perspectives when you look at that information that we're sharing with people, and what you want people to also understand.
A few things from our side.
What it does and what you want them to understand. Yeah.
Right, and so one of the concerns that we have about the way the law is written is that we do think that it's actually quite broad. And this is something I think people should understand. So for instance, you started off by talking about how it's for people who have mental health issues or substance abuse. And that or is pretty important for starters. Because say, here's a scenario that could happen under the law as it's written. You could have someone who is perhaps suffering from alcoholism, okay? And the law says that it's going to be applied to someone that would predictably result in the person becoming imminently dangerous. There's a pretty long walk between those things.
Say that again.
The law actually says, it talks about someone in a situation where that would predictably result in the person becoming imminently dangerous to themselves or to others. It doesn't just say that they're imminently dangerous, predictably result in becoming imminently dangerous. So say the person who's suffering from alcoholism has cirrhosis, which is a horrible disease, and that person has been resisting treatment, right? So there you have someone who has substance abuse, arguably, although the statute never actually defines substance abuse, who arguably has substance abuse, is going to predictably become imminently dangerous to themselves as a result of the cirrhosis, especially if they keep drinking. And if they have been refusing treatment or resisting treatment in the past, then, as written, this law could apply to them. And that seems like a pretty slippery slope when you start looking at a whole bunch of range of conditions that people might have. I think one of the concerns is that people who are watching tonight probably look at this and think, this isn't going to be my concern. This isn't my problem. But when you take a look at the details of the law, people who are watching tonight could find themselves ultimately subjected to this.
I just want to clarify, first of all, that and I've told Connie this personally before, is that I completely admire what IHS is doing. I completely admire, you know, the steps that you folks have taken, that you've gotten houses built, that you have outreach teams going out to people to try to get them into treatment, that your staff is very, you know, understanding, and they are relentless. They really try to work hard, even if the clients are kind of, you know, walking away from them, don't want the treatment. You folks are there as almost like their safety net. And so from the Office of the Public Defender's perspective, you know, we are not opposed to having people get mental health treatment or to get housing if they're unsheltered, et cetera. We just want to make sure that if they do it, you know, that by imposing this law, that it's done while guarding their constitutional rights and making sure that it's not, you know, either forced down their throats or done inappropriately. And so even though the way the law is written, it's broad-based to give a lot of, I guess you would say that give the courts a lot of discretion in how to order it, et cetera. I have some really grave concerns about the constitutionality of the statute. And I think my prediction is that with the few cases that we've been working on, Chris Thomas and myself, et cetera, that eventually we'll be winding up before the Supreme Court on appeal on this.
Give me some examples of your grave concerns.
Grave concern is that the first criteria says that the person is mentally ill or suffering from substance abuse, but it doesn't say seriously mentally ill. So Connie was talking about schizophrenia, you know, bipolar disorder, where the person is severely, you know, hamstrung in living his or her life. But by saying that it's only somebody who is mentally ill, I mean, that could be somebody with, you know, a slight depression, or who's, you know, kind of down about something, et cetera. And if a concerned family member or say like their psychologist or psychiatrist says, hey, you know, I think you should be on medication, and the person's like, no, not really. I think I'm going to petition for you to be under this ACT thing so we can make sure that you get the help that I think you need.
But
So do you want to jump in there?
Yeah,
Who
you
wants to?
probably
Yeah.
wouldn't get it though, because even though that
I'm wondering if there's
criteria-
other language in the law that would, yeah.
Yeah, it's like it's not just one criteria. You have to meet all, and the others, talk about someone being unlikely to live safely on their own, independently, and also, has demonstrated being a danger to themselves or others in the past. And I think for how we're looking at it, when you see years of the behavior playing out over and over, it really is pretty predictable. Every time the person starts drinking, like Josh was saying, they get angry and they start, victimizing other people. It does become predictable with some people, but I also understand your concern if it's just, like what you were saying. But I doubt that the court would actually grant it, for somebody who actually.
And
fits
I
that.
think
Yeah,
you have to remember
Chris
that
jump in and then I'll have a
this
question
isn't a fact pattern or a debate that's in the ether. These are folks that are under the care of historical care workers, licensed social workers with IHS, who are then evaluated by a doctor, a psychiatrist, a licensed psychiatrist who outlines a treatment plan. And so this isn't lawyers determining who is mentally ill or who is suffering from substance abuse. These are doctors, these are healthcare professionals who are making these diagnoses.
So I wonder if it sounds like some of the concern here is the language in the law written in a way that it assures that's going to be the result
Applied
of
only
what
to those
happens?
people. No, it's not.
Or is it strong enough, do you feel? It sounds like because of the different levels of criteria that it would ultimately lead to those individuals as far as.
Well, I
that
think
fair to say?
that's probably a subjective opinion, but
Yeah.
I rely on the judge, in the presentation of the facts of the case for the judge to decide whether this person would need the treatment. But not only that, most of the time they're actually appointing a guardian ad litem to act on the person's behalf as well.
But one of the concerns, because you were talking about the subjectivity, one of the concerns that we've got is that some of the more objective criteria that used to exist in the law, and once again, the ACLU had real concerns about the law previously anyway, but it had some more objective things such as showing a history of previous hospitalization, which I believe have now been stripped from the law in the amendments, because these amendments were written to make it easier to subject people to this law. So you've taken out some of that objectivity that was in the law to kind of grease the skids on this a little bit. And that's one of the concerns that we've got as well.
And I think the reason why it was taken out is because some people have gone for years without any hospitalization or any treatment at all. And we're talking about people who sometimes have been on the street for over 20 years. And so it's really pretty sad, that they've never gotten treatment before. And so, with that caveat, if they never were hospitalized before, we wouldn't even be able to bring them if, that was part of the law still.
I'll let you guys respond, but let me jump in and get a couple questions in here. This is from Nico via Twitter. He says, will ACT be limited to those with severe mental health conditions diagnosed and treated by medical professionals, or will it also open the door to coerced, non-medically supervised, he says, quote, treatment and detention for those who use substances? Is that an area that you feel, what's your response to that?
The focus right now is on people who have severe mental illnesses, but because the language of the statute doesn't limit its application to that, it certainly could be used on people with substance abuse. And I cannot think of cases that have been brought, because we're kind of too new into this situation now, where the person is solely a substance abuser and doesn't have mental health issues. So I can't speak to that, but the language in the statute about its application to somebody who is I want to say purely a substance abuser is not clear enough, and it's very vague. So I think what the caller or the viewer was talking about is a possibility, and that's why the ACLU is concerned. That's why my office is concerned about the broad-based potential application.
So what's more, what do you see happening then? If they're not committed to a psychiatric facility, do you tend to see more incarceration? What's sort of what you're seeing happen
Absolutely.
otherwise?
more incarceration, more arrests that result in them coming back into the community, you know, and it's a lot of wasted resources. You know, whenever they go in, it's, you know, costing another, I don't know how much it costs for one emergency room visit, but, you know, that whole cycle of going to the emergency room, being released, finally committing a crime, that you end up in jail again, that is just really not, you know, acceptable if it's a treatable condition.
And if I could just point one area where I'm guessing we probably do agree, and is that the ACLU, like the public defenders, wants people to be able to get treatment. And we want people to get the resources they need, the housing they need, which is a critical part of maintaining their lives. Where our concern is whenever that becomes coercive. And one of the concerns we have is that there seems to be so much effort being put into coercing treatment that ends up diverting resources away from getting people who are actually seeking treatment the assistance that they need. And there have been studies done on this. There have been, I think it's technically 3 would have been considered kind of the gold standard of clinical research studies with randomized controlled trials. And what those have shown was that coercive treatment really didn't make a difference. But when there have been patients who've been interviewed who have been coercively treated, they were so traumatized by it in some cases that they had a hard time then voluntarily seeking treatment in the future. And when you tie that in to the concerns, for instance, that we have about bodily autonomy, because there's not a civil right that's much more fundamental than having the control over your own body. And when you take a look at some of the gaps and the vagaries that's in the statute that we've already discussed, we think it's entirely likely that you could have those violations of bodily autonomy and that kind of breaking of trust that's really necessary to maintain that long-term therapeutic relationship.
Well, I want to give people a chance to respond, but let me get another couple of questions in here. Wesley from Kahala asking, what would the ACLU do about the seriously ill people on the streets? Would they ignore them? What does society have an obligation to do to help these people? So what's the alternative here if we've got a situation where an individual appears to be at a stage mentally where they may do harm to themselves or to others, or they're in a severe health situation?
Sure.
What's the alternative?
So a few things I'd say on that. One is there's a man out of San Francisco. He was the former CEO of the Mental Health Association of San Francisco, Eduardo Vega. And I think he'd put it pretty succinctly when he'd said that force isn't treatment. And what he had talked about was, in his experience in working with the houseless communities in New York and others, this patient and persistent outreach in developing these relationships with folks is what really made the difference in the long term. But there are also other things that a group like ours would be perfectly willing to take a look at if applied correctly, things such as psychiatric advance directives. So if you have someone who's gone through a psychiatric crisis and they know what worked and what didn't work, and perhaps even what medication worked to get them out of that, and at a time when they were acting in a truly voluntary fashion, and that would be an important criteria for us, you know, not that it maybe looked voluntary but wasn't, they signed that, and that could be something that would be applied to them later. That's another kind of thing where we wouldn't have an objection to that.
Well, see, I think there's a misnomer that every ACT order that's sought or implemented is a scenario where medication or treatment is being given against someone's will. That is not always the case. There is opportunity within the law and within these orders for voluntary treatment. These folks have the ability to acquiesce to the treatment just as easily to resist it. And we also have to remember that in terms of acquiescence or resistance, the statute does require that they're incapacitated. They may not have the ability to determine what they do want. And in that regard, you know, the society has to balance the interests of the individual versus the need to protect society. Obviously, we need to protect the individual's civil rights, but we also need to protect folks living amongst us in our parks, children who encounter individuals who are mentally ill or severely substance abusive. And so we appreciate the civil rights concerns, but we also appreciate the need to protect society. And I believe that this ACT law gives us that unique opportunity to balance those and implement and do both.
I think we have a little, real quick, I think we have a little video we want to show here just to kind of sort of show, you can't tell who the individual is, but if you want to take a look at the monitor behind you, you kind of get a sense for sometimes some of the individuals that you do see out there, and you think to yourself, you know, how are we supposed to address this individual or address the issue that is before us here? What are your responses when you see a video like this?
Okay, my first response is that I see the man is on the street, and he's endangering himself. I think that's the street that's being shown. I could be wrong. But if that's the case, then he's endangering himself by placing himself in...
approaching this individual here.
Right. In traffic, he's... Okay, perhaps he's...
So it appears that he was harassing that individual in some
Right. Okay. To me, that sort of a situation is ripe for police intervention, because here he's harassing somebody or threatening somebody, and the police have an absolute right to step in there, arrest the man for that type of a crime, although it may be mentally health related, because you know he's off his meds and he's deep into his mental health illness. But in those cases, what they do generally is to take them to Queens or a hospital, have them evaluated to see whether they need to be held. And if somebody is imminently dangerous like that, I mean, he was chasing after that person and it appears that they're imminently dangerous, then they need to be taken out of society and treated, like if medications do work to help them to, you know, become more focused and to not persist in those kinds of behaviors, they can be safely released back into the community. What I see a problem with is that with the ACT, is that I mean, there's kind of a disconnect. I mean, I wanted to respond to what Chris was saying about voluntary. Somebody is perfectly fine. Public Defender's Office has no problem if somebody wants to voluntarily submit themselves to an ACT program or treatment, and that's kind of fine. Where our office becomes involved, and probably where Josh's office becomes involved, is when people either don't know what's going on, or they actually don't want to participate in it. And some of the people, like the lady or the man that you were talking about that may have not had treatment for 20 years, I'm sure it's not for a lack of trying on your folks' behalf, but the guy has just, you know, said no, or he's not interested, or something more important to him is going on, and so, you know, treatment is kind of, you know, less important to him, and so his life goes on.
I want to say what commonly will happen to that gentleman is that he will be taken to the emergency room. They'll MH him. He'll go to the emergency room, and he'll refuse treatment. And
What's
they will
MH him?
I'm sorry. That means that, you know, the police may take him in, but then they won't be able to hold him because he won't be any more immediately dangerous. And so if he refuses treatment,
the cycle continues.
Yeah, then he just gets released right back into the community. And for that gentleman that I know, it's happened many times before. So we're trying to break that cycle so that he can get some treatment, so that, you know, he would be able to actually have a life in the community.
What's your thought, Chris? I mean, when you're hearing the comments so far, seeing that.
Well, the answer when we see a video like that is, well, we should incarcerate him, we should detain him, we should put him in jail. As Connie was alluding to, this law gives us the opportunity to not only treat the individual, but do it outside the confines of incarceration. And so if we're going to break that cycle, continually putting them in jail or into the hospital, and they continually come out without any better situation, why wouldn't we act upon the opportunity to treat them in the community? It's my understanding, and I'm not an expert in the medicine, but that there are medicines available to folks with schizophrenia and other maladies that have a very effective means of managing mental illness over a long period of time. There's time-release drugs that can be given. And so my understanding from talking to Connie and her folks is that they have had success with these medications in managing people to the degree that they are able to have the wherewithal to seek further treatment and to better themselves and to live more safely amongst us.
And two concerns, if I could just raise. One is, and I just really don't want to have this lost, because videos like that, it's easy for people to look at that and be concerned. And again, I echo, by the way, everything that Phil said about the work you folks are doing. God bless you for being out there and doing it for as long as you have. But I think it's critically important that people at home watching tonight understand that it is a vanishingly small percentage of people with mental health issues who are ever violent towards anyone else. And I think it is often kind of conflated. And this is part of, unfortunately, kind of the dehumanizing that happens, especially with people who are houseless in the population, that, oh, you're houseless, you're walking around, you should be scary. Most people who have mental health issues never commit any violent acts. And so that's something I think that we just really can't lose sight of as we're having this
really does
conversation.
kind of allows you to kind of sort of continue on this, but I just need to address some of these questions. And I think it's along the thread of what you're talking about here as far as how we sort of deal with the perceptions and handle the different things that we see. This is from Jim from Facebook. He said, I'd like to hear what the ACLU and the public defender have to say about protecting the constitutional rights of the public who visit public parks and beaches without being subjected to aggressive homeless people or having to look at people defecating in public. So obviously, sir, this has kind of been one individual's experience, and they're saying, hey, what about me? If I'm out there, what are my rights if I'm having an issue with this, I'm feeling threatened, I'm not feeling safe in my environment?
A couple, I can go first and then kick it back to you. Two things. One, Phyllis had mentioned something before, which is true, which is that there's someone out there who is committing an independently criminal act. Then our organization isn't going to come out and defend them for doing that. If there's someone who assaults someone else, that's a crime. And that is something for which they can be prosecuted. But I think this also really gets into this question of perception. There is something that happened, I think it was about a year ago, and I've talked about this before, that there was an attack on a couple of Japanese tourists in a park in Kaka'ako. And shortly after that attack happened, there was a lot of speculation that the attack was done by someone who was houseless in the park. Turns out the attack was committed by someone who I believe lived in Lanikai, and it was stopped by a couple of houseless people who were living in the park. And I bring that up just to kind of make people realize that sometimes those perceptions just come out of a misperception, and that we really do need to try to focus on the fact that these are just members of our community.
And what's your response also to Jim's?
Well, first, I would agree that I really feel like houseless people are stigmatized and that they're stereotyped. But we're talking about people who are diagnosed mentally ill or have a serious substance abuse problem. We have one of the worst methamphetamine epidemics, across the country, and we've lived with it for scores of years now at this point. And when I was at the state hospital and saw a lot of the patients there who were coming in on forensic orders, they had committed crimes, but they were also, high on ice or had long-standing addictions to ice. And when you have that, it impairs your brain after a while, and if you don't get treatment, it will continue to debilitate you. And I think a lot of these conditions that we're talking about.
So what you're saying is that if they were to somehow miraculously just stop taking drugs at that point in time, that oftentimes people say, hey, you should be able to just have the will to do it. They're still in a state based on the damage that's happened.
Right, and the
that can't be reversed at that point in time.
Right, there's brain damage, and that's what I'm trying to say, as a person who's a healthcare provider, a mental health provider, when the brain is damaged in that way, we call it high impact neurological conditions. There's an impairment of that, your brain, which is responsible for your thinking, your feeling, and your ability to act. And so if you can't do that with the normal function that you would normally have if your brain was intact, then you're impaired. And if you're impaired, there's definitely your choices are not going to be great.
My response actually answers yours. It doesn't talk to Jim's question, but since it's on the table, one of the concerns that I have is that if there is a person who has brain damage because of methamphetamine use, for example, and we do say he also has a schizophrenia or some other serious mental illness, and we get him treatment, if that person continues using drugs, or if that person has been so damaged mentally that they can't function, in society to, continue to take his medications, to get himself shelter, to, eat properly, etc. I'm not sure that we've solved the problem as far as that particular individual goes. He may still be houseless. He may still be unable to fend for himself or care for himself, and the medication is not the magic bullet that's going to answer this.
No, definitely not, but it is the beginning. Because once you can restore some cognitive function in that person, they can start to make some different choices. And treatment is not just medication. We always say that it's much more than just medication.
Let me make sure I get to a couple questions here, because I think we have more coming out. And I think this is kind of partially in line with talking about the law itself and also just sort of the environment we're dealing with here. This is from Janet from Makiki saying, are we talking about, say if we're talking about mandating or addressing the individuals that we're focusing on, are we talking about giving pills or forcing an injection? And what happens if the individual does not follow up on that treatment? So she's kind of sort of looking at, I think partially sort of looking at the law situation, maybe not totally understanding. And when we're talking about an individual,
if I could respond to that, that's one of my concerns, because there is a chapter in here, section 334-129, that says failure to comply with assisted community treatment. And if somebody doesn't follow the treatment plan, the treating psychiatrist or an APRN, which would be an advanced practice registered nurse with prescriptive authority, and there's some other criteria, may prescribe or administer to the subject reasonable or appropriate medication or medications if specifically authorized by court order. As I read administer, to me that means that you can actually force medicate the person as long as there is an order by the court saying that it's okay to force medicate them. The ACT allows the judge to impose this treatment plan for a year. So that means regardless of whether the guy's dangerous now, right at this moment, say January the 1st, he can be force medicated, all the way till December 31st of that year.
Let me let Chris jump in here, and then I got to get to a couple of questions.
One thing to mention is that the initial goal of the ACT order is to attempt to get the medication taken or administered voluntarily, and Connie and her folks are very good about doing that. If that doesn't work, then they have somewhat softer coercive measures to try and convince them it's the right thing to do. Only in a very extreme circumstance can an individual be transported to an emergency room in a clinical setting to be administered with medication if they refuse it. So this isn't a situation where a doctor on the street can walk up, drag somebody to the ground and shoot them with a needle. They have to be following the statute, brought to an emergency room in a clinical setting, which is no different than if they were picked up by the police, and they're given the treatment and that criteria. So, so to answer your question, the medication can be given and administered in that situation, but it's not the initial aim of the ACT order.
I'll let you jump in, but let me get a question in here first, because we're starting to pile up a little bit here. This is from Rachel from Kauai. She's saying, as a consumer, I feel it's been helpful to have been taken to a facility for treatment, and it's critical to make it easier to intervene to get help. I can't just leave people out there. So if you want to, I don't know what else you want to respond to, but she's saying, hey, we kind of need to get them in that sort of space where we can sort of control the situation in some shape or form.
And that's an example of somebody who has had their cognitive abilities restored. And she recognizes that when she's suffering from her mental illness, she can't make those decisions on her own. And so it's, after someone gets the medication that they're able to make better decisions. I've seen when some people who actually have been both mentally ill and suffering from an addiction, after getting medication, they actually use less and they start to consider going to treatment for their addictions as well. So it's really, many opportunities, to benefit them.
Now there is a flip side to that. A couple of examples. One, there are a couple of psychiatrists, Dr. Dinah Miller and Annette Hansen, wrote this book called Committed, The Battle Over Involuntary Psychiatric Care. And they worked very hard to show both sides of this. They interviewed people who were in favor of it and people who were opposed to it. And they interviewed a number of patients who talked about having been forcibly medicated and the trauma that caused them. One of the people that they interviewed actually had specifically said she was so traumatized by it, she didn't think she could ever go see a mental health professional again. And she talked about having recently had twins, knowing she was susceptible to postpartum depression, and still not wanting to go to treatment because of that. And that's not just theoretical. I have spoken with a social worker who's been working in the mental health arena for over a quarter of a century right here in Hawaii. And two things that she had told me was she knows a number of people who have very similar stories. They're forcibly medicated, and as a result, really have trouble now going to voluntarily seek treatment. So this may be short-term Band-Aid caused long-term damage.
I'm going to let you respond. Let me get this question in here, though, because it's related. This is from Nico from Twitter. He says, what operational and legal mechanisms are in place to ensure that appropriate medical standards of care are followed? Will patients have access to independent counsel to pursue private rights of action if necessary?
I can speak to that. The statute does afford patients the public defender's office. However, it also allows them, if they don't seek counsel from the public defender's office, to hire their own attorneys. And they also have the ability to request their own independent psychological evaluations. So it isn't as though we're relying only upon the doctors that are procured by Connie Mitchell and the IHS. They have the ability to get their own independent evaluation if they wish to do that. So that to answer that question, there is counsel afforded them, but they can hire their own also.
I mean, one of the problems that I see, though, is that a lot of the clients that we handle, well, all the clients that we handle are indigent, so they couldn't afford to hire their own attorney, which is why they have us. But as far as getting a separate psych eval from an independent contractor kind of a person, that also would be.
Do you get a lot of requests for representation for people who are mentally ill?
It's automatic. It's automatic. So part of the Act statute says that if they file a petition, public defender has to be notified, and we are automatically appointed to these cases.
It's also worth noting that besides the public defender's office, a guardian ad litem can be and is often appointed in these cases. So we have another layer of due process, another layer of protection for the individual built into the statute with a GAL. And so in terms of asserting their legal rights or seeking counsel, they have a court-appointed attorney for them.
Okay, I'm sorry.
It's okay, go ahead.
Okay, I wanted to disagree with that in a little way, which is I want to clarify that the public defender's job really is to protect the legal rights of the clients, the legal interests of the clients. The guardian ad litem is appointed for that hearing. They look at basically the best interest of the client, so they stand in the shoes of the client. If the client were lucid, they make decisions based on what's in the client's best interest, and that's kind of broad and undefined. And that's different from even the MD, which is looking at the best medical interest or the psychological interest of the client. So, you know, my position or what I do is different from what a GAL does. And
GAL, what is the GAL?
Sorry, guardian ad litem, meaning a guardian of the person for that case, for that hearing.
Let me get to this here. What treatment protocols and guidelines have been established to ensure that those impacted by the new law are subject to continual medical supervision and not detained any longer than necessary to stabilize their condition? What can you speak to for the new law?
Real quickly, I'll turn it over to Connie. The statute requires that a care plan be filed with the petition, which is a licensed social worker in our cases to have a long-term care plan. And then that care plan has to be adopted by the psychiatrist who's treating, and that psychiatrist has the responsibility of following up in terms of the treatment. So, and the orders are only a year in duration. They can be extended and they can be terminated short of that, but the obligation is for a year.
And there are standards of care that psychiatrists and other mental health workers have to follow. You know, I think it's important to note that when we do go for an act order and we have an intention of implementing a treatment plan, there are different monitoring systems, of people looking at the case and saying, are you, actually doing what's, good for the person? But I think, when, for us, it's always about a patient-centered treatment plan. So we want to give the person as many choices as possible, and as they resume their ability to make choices, we want to give them those choices.
I'm going to let you respond in just a minute. Let me get to this question, and then you can respond. So Amanda from Honolulu is saying, who is liable if the person being subjected to treatment has a severe negative reaction? And what is the minimum amount of interaction with a doctor required before intervention can be initiated? So two questions here. So both of you jump in and then make sure Josh gets it.
Okay, there is no minimum amount of interaction required by a doctor. The doctor just has to evaluate the person, determine that he or she suffers from mental illness or substance abuse, and that is in need of treatment. Treatment would be in their best medical interest. And to speak to Connie's previous point, although that IHS may be following up with the person in the field, the court basically loses the case. I mean, they close the case. And although the act may be in place for a year, the court doesn't go back and supervise. They don't ask for reports to see how the person is doing, et cetera. So we kind of have no idea. We just know that there's a paper out there that says that the person has to be under the
And
act.
I'm going to revisit that again because
Okay.
of some questions, but
And this, I think, also gets a little bit to the intersection of the civil rights concerns and providing something that I think everybody at this table wants, which would be effective long-term treatment. And people generally have a pretty good sense when their rights are being violated or when they're being imperiled or when they're being coerced to do something, and they generally push back against that. And that's one of the concerns that we have is you have that intersection where whether you think it's a good idea or not, regardless of whether you think it's a good idea to coercively treat someone, I think we can all agree that there is a violation of their bodily autonomy when you do that. We can argue of whether it's a justifiable one, but it's a violation of their bodily autonomy, which we think implicates the civil rights. And the other things that then come into play are some of the other kind of downstream effects of that. So someone else I've spoken with recently who works in the mental health arena right here in Hawaii had pointed out that one of her concerns upon looking at the law is that you could have someone who is coercively treated in a way that is culturally inappropriate for them. And once that's happened, the damage is done. And that could be culturally inappropriate just because of their heritage, their background. It might even be because of their religion. For instance, just one quick example, we don't make people accept blood transfusions if they don't want it.
now if somebody is severely ill, how would you know that? I would think some would be more obvious, but other situations may not. You may not be able to get that information. Or would you?
And this is,
What do you mean by?
as far as, say, if you're talking about, say, their religion, or if they're talking about what they might be culturally sensitive to, if they're not able to communicate that, how would you?
You don't get it, I think.
Yeah. So
Well,
if that's,
but the fact is that mental health or psychiatry, has a set of standards and a set of criteria for providing a diagnosis. These diagnoses are recognized throughout the world. It isn't just, in the United States. And I agree, with Josh that there are cultural issues, that come into play. If you're providing good mental health care, you take into consideration a person's cultural background in your assessment of that person. So clearly, you have to be sensitive to those things, but there are other objective things when somebody is clearly responding to voices in their head, or they're actually acting upon in a way, or not acting to seek treatment for a very serious condition, that there are oozing wounds that they're carrying around with them, they're just not making good decisions, and I don't think anybody would disagree with that.
although, and I think it's also worth noting that there are lots of choices people make that may not be great choices, but as a society, we have decided that they can make those choices. And so that could be the earlier example I'd made. If you're an alcoholic and you're still drinking and you've got cirrhosis, it could be riding a motorcycle without a helmet. It could be if there's someone who's in stage 4 cancer and they've decided that they don't want to have any chemotherapy, even if there is what their doctor considers to be a good course of care afforded to them. But we have decided that they're allowed to make that choice, even if it's not a choice we would make.
I want Chris to expand on that a little bit, but I also want you to sort of consider there's a comment that you made about individuals having a sense that they're being coerced. What's your response to that? If that's sort of the part of the argument that Josh is making, that people generally have a sense that they're being coerced in the context
I
of this
think it
law.
goes back to one of the prior questions of, is there a trauma or is there an effective, detriment to having someone take medication against their will? I point to the question about the individual who is concerned about, someone who is mentally ill or substance abusing in a park, and the trauma that causes to that individual or those children who see that person expose themselves. And so again, that goes back to the balancing test of, if we're going to be looking at an individual's civil rights, we also have to look at the needs of the society to be protected against these individuals if there is a situation where they are acting in a criminal or a mentally ill manner. And so in that situation, I believe that the statute and the precedent allows us to medicate these folks.
Well, I want to add on to Chris's comment, which is that for the gentleman from Kahalo who was saying, you know, what about my rights, you know, and my kids get, you know, see somebody defecating in the park, etc. You're not supposed to do that, period, right? So he has a right to go ahead and call the police and let them intervene with the person. And the big question, I think, is what happens from there, okay? And I see a problem with Hawaii's mental health system. It's just not a hot button issue. It's not a sexy issue that legislators want to throw money at, or even the community wants to throw money at. But good God, we have so many people who need mental health treatment. And so Queens, HSH, Hawaii State Hospital, they are bursting at the seams with people who have, who actually need treatment, more substantive long-term treatment. They don't have enough beds. And they're constantly finding ways to discharge people before they're really ready to be discharged. So those are the people that I believe wind up houseless, on the streets, kind of bumbling around, and that, you know, the man in Kahalo will see, etc. There are and that continue to cycle through the system. And so I think sort of the underlying thing is that we really have to work on improving the mental health system in Hawaii. I mean,
well, I would say that our mental health laws are preventing us from actually being able to treat some of those folks if their sickness or their illness in itself precludes them from making a decision to receive treatment. And then we have that whole cycle starting up again. And I do have to say that I think that a lot of the laws were made way back when, you know, we had medications that really had bad side effects, but they've come such a long way that you don't see the same kind of side effects anymore. You know, where you used to have the shuffle, you know, or the pill rolling, you know, all these involuntary movements that came out of some of the medications that were used before. We have a different class of medications now.
well, except that one of the medications that was being suggested for a client of mine recently is that Invega Sustenna, and I looked up the patient insert thing, and there are lots of different downsides, including irreversible, like tardive dyskinesia, and a lot of irreversible problems. And so if the person was on par and able to make a decision for himself or herself about whether to take that, he or she might rationally say, no, I don't want to take this thing because of these possibilities
But usually when those start to happen, the person has compensated and they can make a choice, to maybe not want to take it, but they're not even given that choice.
Let me get to, we only have a few more minutes left, so I'm sorry, I just want to make sure we get a couple more questions in here. Bob from Kaneohe is saying, how many court orders are in place right now? Where are we at? Are there court orders in place with this new law? Or there's a case that came up earlier this week, is that correct?
Well, are you talking about the 2016 amendment? Excuse me, the 2019 amendment.
Right.
Just kind of went into place in July, yeah?
Yeah.
August, yeah.
Yeah, and so
what's
cases are
happening
starting right now.
So we have no cases that have passed.
But there are cases where the act has been granted under the older law or older laws. And some of them, because they're voluntary, we don't really hear about them unless, of course, the petitioner wants to re-petition and have it continue on for longer than a year, or at the expiration of that period. So, there are cases out there where the act has been used.
Let me get this one more time. One more question in here, and then I'll let you guys respond. Lloyd from Waiʻi is saying, what is the feedback from individuals who have been in court-ordered treatment? So I think that he's talking a little bit more before this recent amendment. What kind of feedback have you gotten when you have been able to get some feedback for people who've gone through court-ordered treatment? Thankful, resentful? What type of feedback can you talk to?
Well, we haven't had that discussion with anybody, and we haven't had enough of them. But
even before this recent amendment.
Yeah, without the ACT orders.
Yeah, even before.
Well, I think like the gentleman that you helped us get one on the old order, he actually had never had that question posed to him, but I think that he appreciates being housed. He appreciates not living at the bus stop anymore. He appreciates the fact that he was able to go to his father's funeral when his father died and to have a renewed relationship with some of his family members. So it's really about, trying to find ways to help people be able to have a normal life as they can in the community.
Final thoughts, Josh?
So I think it's a good time to just for people to remember that this is a complex issue. It doesn't have a simple solution. And one thing that we've generally seen over the course of our country's history has been that when we do things simultaneously looking at the civil rights implications, even if that makes it harder, when we try to make sure that we are passing public policy that also keeps that in mind, we generally end up with better solutions. And where we need to be doing some of the hard work, and the hard work that IHS is doing is putting more resources into those types of resources that more money that people into resources people can voluntarily accept, so that we can start reversing some of this. Because if we just keep coercing people into treatment, and I have spoken with people locally who said they've gotten negative reactions from that, you're perpetuating a bad cycle.
I'm going to have to end it there. So I was about to say the debate continues, but I'm going to say the hard work continues with all of you, because this is, as you know, an important issue and all of you care so much. We appreciate you being here. So mahalo for joining us tonight. We thank our guest, Connie Mitchell, Executive Director of the Institute for Human Services, Josh Wish, Executive Director of the American Civil Liberties Union in Hawaii, Chris Thomas, attorney representing IHS in court petitions, and Phyllis Hironaka, attorney in the Hawaii State Office of the Public Defender. All right, so this is our last Insights episode for the calendar year 2019. We return on January 9th, 2020 to preview the upcoming legislative session. Until then, I'm Laurie Amata for Insights on PBS Hawaii. Ahui ho.